Good morning. Welcome to Division 7 of the Court of Appeals. We have two cases on the docket this morning. The first is Herlock versus A&A Quality Appliance. The second is Hernandez versus the City and County of Denver. I see that counsel for the first case are set up and ready to go. Have counsel checked in for the second case?
Yes, sir.
Okay, good. Okay, just a couple of things. I'm sure you've had a chance to go over our written procedures. Do you have any questions about those? No? Okay. And I just want to remind everybody of a couple of things before we get started. Please turn off your cell phones as they, for some reason, interfere with our live streaming or recording or both, or one, I don't know. And then the other thing is, don't forget that the podium has a toggle switch on it so that you can raise and lower the podium as needed. We're ready to proceed in Herlock.
May it please the court, my name is Jessica Scott, bar number 37287. I represent appellant and cross-appellant, Appliance Factory Outlet, or AFO. This is the second time this case has been before the court, and the first time this court made two critical holdings that should have but did not control on remand. The first holding was that this court agreed with the district court's initial determination that the compensation term was ambiguous. The second critical holding was this court found that both parties' interpretations of that ambiguous term were reasonable, including AFO's. Therefore, the compensation term could be interpreted to mean either $50,000 annualized for a 6-month period or $50,000 for 6 months of work. Despite those key holdings by the court, the district court on remand said otherwise. It said that AFO's interpretation of that same compensation term, quote, defies common sense, and thus essentially discredited all of the AFO employee testimony that nobody agreed to pay Herlock $50,000 for 6 months of work. The district court erred again, and this court should now reverse and direct the district court to enter judgment for AFO on all claims because there was no contract.
Counsel.
Yes.
It seems to me if the arguments you were making on appeal now were correct, the case would have been terminated in the first appeal. It seems to me the court in the first appeal only said that on its face, this one document is ambiguous, on its face, and remanded for findings to resolve that, and that's precisely what the court did.
The court didn't say on its face. It said we are faced with this document, a document that says $50,000 for 6 months or greater for compensation. And the court held, look, AFO says it means one thing, Mr. Herlock says it means another. And we find that both parties have presented reasonable interpretations of that contract. We see nothing from the trial court that shows where there was a meeting of the minds. So they gave the court a second chance and said, look, show us where you see the meeting of the minds.
But your argument is that the court's finding, the division's holding on ambiguity bound the district court on meeting of the minds.
Well,
if that's so, there wouldn't have been a remand.
That's not true because, first of all, the district court in its original judgment said that that phrase was ambiguous. The district court said that. Then it went up on appeal, and part of the problem with the district court's first reasoning was it said it was ambiguous, and then it said, I'm going to construe that ambiguity against AFO as the drafter, which is actually a construction of last resort, and that was one of our arguments on the first appeal. Instead, the trial court had applied it as a construction of first resort and therefore colored all of the AFO testimony accordingly. That was one of our arguments in the first appeal. The Court of Appeals agreed and said that phrase is ambiguous. We find that. So there has to be a meeting of the minds because there was case law presented in the first appeal that said if there's only one reasonable interpretation, you don't really have to have a meeting of the minds. That's an exception to the meeting of the minds rule. And this court held, look, that exception doesn't apply because it is ambiguous and both sides have presented reasonable testimony. So that phrase is ambiguous. It can reasonably be interpreted. But, District Court, we don't see anything in your order that shows us where meeting of the minds was, and cited the real estate diversified case for the proposition that perhaps there could be some evidence that one party knew or should have known of the other party's interpretation or what it really meant. So it goes back down, and now the trial court is specifically asked to talk about meeting of the minds. The trial court looks at that issue, and essentially all the trial court does is look at the same use of that phrase over and over and over again, used in oral conversations. The same phrase this court held was ambiguous, the same phrase this court said could be subject to two reasonable interpretations, and said, look, it must have meant Herlock's interpretation all along. But there was nothing other than the use of that same phrase. It's circular reasoning.
The counsel, there was testimony as to what the parties understood. Now, I understand you might not like that, but there was. And it was the trial court's job to resolve credibility. The trial court expressly found your witnesses not believable.
So the testimony of what the understanding was of the terms was, again, the use of the phrase. Herlock said, I thought it meant one thing. AFO said, we always intended it to mean something else, and we always said $50,000 guarantee for 6 months.
And the trial court said, I don't believe you. And that was the trial court's prerogative. We can't second guess that.
Let me tell you, there have only been two credibility determinations identified by the trial court. The first was in the trial court's very first order before this court saw the case. And the trial court then said, I don't buy AFO testimony that they have never agreed to $50,000 for 6 months of work, because they did in fact agree to it here. That was the extent of the credibility findings in the first order. Now, that was the same phrase that the trial court said was ambiguous. So the reasoning was completely circular. They did in fact agree to it here in the document that everybody agrees is ambiguous. Now, in terms of the second time, now the remand, after this court sees the case, it goes back down on remand. The only thing the trial court said she did not find credible was Mr. Draco's testimony that a K, she said, a K could not mean annual. That doesn't make any sense. You look at his testimony, that isn't what he said. What he said was, I don't write annual when I'm talking about compensation. I write something like 70K. To me, that means annual. Herlock himself testified that that's how he writes, that he doesn't write the word annual. He writes 70,000 to 100,000, and that everybody writes that way, and it's supposed to be understood that that means annual. That was Herlock's own testimony. Further, that credibility finding, again, said, I just don't buy that $50,000 for 6 months could mean $50,000 annualized. But that's directly contrary to what this court said in the first appeal. That is law of the case. And this court said $50,000 annualized for 6 months was in fact a reasonable interpretation of an ambiguous contract.
But Mr. Herlock testified as to his understanding of the conversations as to what that meant. She found that credible, the trial judge.
At that point, his misunderstanding of what AFO was telling him, that's not that doesn't matter. The question is whether the parties, when they were speaking to each other, both meant the same thing.
And
Yes,
Mr. Herlock testified that they did discuss that it was going to be $50,000 for 6 months.
the same phrase. In all of the conversations he identifies with AFO employees, it was the same phrase used over and over again. $50,000 guarantee for 6 months. $50,000 guarantee for 6 months. And that is what this court found could reasonably interpret it to mean $50,000 annualized for 6 months. This court already held that. So to use the same phraseology that appears in the status change form that this court determined was ambiguous and could be reasonably interpreted, to use that phrase and say somehow now it's no longer ambiguous when used the same way in oral conversations, there's no connection there. That doesn't make any sense. I mean, it is the same phrase used over and over again.
But the difference is credibility. I mean, in the one case, you have just a document on its face, and then you have testimony. The credibility is weighed and determined. That's the difference.
Again, the trial court's two decisions on credibility were not supported at all in the record. And furthermore, the main holding by the trial court that discredited the testimony was that it defies common sense to suggest that $50,000 for 6 months could possibly mean $50,000 annualized. But this court held otherwise. And the trial court was bound by that. Now, you get then to the next question of how Mr. Herlock could possibly be entitled to the full contract price when he voluntarily quit after 2.5 months. To this day, neither the trial court nor Mr. Herlock has presented any sort of case law that supports such a result. The anticipatory repudiation doctrine, all that does is excuse his performance. There is no sort of support at all to say that he can stop performing and collect the full amount under the contract. Then you get to the next step, which is the application of the Wage Claim Act. As an initial matter, it was not a determinable compensation term because the trial court denied summary judgment, said I need a full trial on this to figure out what he should have been paid, what he was owed. We've now been up to the Court of Appeals twice, where this court agreed it was an ambiguous term. To suggest that somehow this was a determinable compensation term, it just cannot apply under the statute. Further, the Lee case
Counsel, let me ask you about
Sure.
that. This notion that of him quitting. If it's a guarantee, it seems to me your position is, and I'll make this a little more hypothetical, the employer guarantees or agrees, just simply agrees to pay an employee a wage. Employee starts working. Employer says, I'm not paying you a dime, okay? Seems to be your position that the employee has to stay on working for free in order to collect damages for the employer's breach of a contract.
The employee does not have to continue working. The employee can stop working and sue on the contract. But what doesn't get to happen is he doesn't get to collect the entire amount. There is no support. There is not one case that has been cited to this court that says you get to stop working, not mitigate your damages, an issue which was never cross-appealed. The trial court said that there was credible evidence of lack of mitigation, and collect the entire contract price. The Lee case also talks about that. A question of guarantee is two separate questions. There is as long as you work for us, we'll guarantee you an amount of compensation. There's that type of interpretation of guarantee. And then there's the second question of, well, have you guaranteed them a set time where they're going to be employed? Two separate questions, said this court in the Lee case. The trial court never analyzed that second question, the question of whether he was actually guaranteed to be employed for 6 months. Never analyzed or answered that question. It said, look, I say you get $50,000 for 6 months, I don't even need to get to the second question. That's not true. They're two separate questions, and the trial court never went that far. And further still, again, you have to show some sort of right to employment to get a constructive discharge type claim. The only evidence in this case showed that he was given and signed employment documents that said he was terminable at will. That is exactly contrary to suggesting that he was guaranteed to be employed for 6 months. I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
May it please the court, counsel, Alan Epstein on behalf of Joshua Herlock. At counsel table with me is Elwin Schaefer. The first issue that AFO argues is that as a matter of law, there was no meeting of the minds between the parties because plaintiff understood $50,000 guarantee for 6 months to mean that AFO guaranteed him employment for 6 months for a 6-month salary of $50,000, while AFO understood $50,000 to be annualized. This was the same argument AFO advanced in the first appeal, but this court remanded for further findings of fact. If the record compelled the conclusion that defendant wants this court to reach, it would have reached that conclusion the first time because it's the same record. If the evidence establishes that both parties originally attached the same meaning to a contractual term and they later disagree on its meaning, the determination of the term's meaning is a question of fact for the trial court. Based on the parties' discussion of salary at the time Helzer contacted plaintiff and the fact the plaintiff was leaving his position at Home Depot to take on a commissioned position with defendant, the trial court's finding that the parties ascribed the same meaning to the salary term at the time of contract formation is supported by the record and must be affirmed on appeal. The issue is not whether the term on its, the language is ambiguous. The issue is what the parties ascribe to the meaning of those words at the time of contract formation. And the fact that other employees did not have the same agreement is not, as defendant argues, outcome determinative. It was one fact for the court to consider, but it does not mean that AFO did not originally intend to give plaintiff that deal in order to convince him to leave the his employment with Home Depot and come work for AFO.
Mr. Epstein, what exactly is the evidence supporting the trial court's finding that at the time of contract formation, both parties understood the contract to guarantee $50,000 for 6 months? Is it simply that he used to work at a non-commissioned job and now he was switching to a commissioned job? Is that the only evidence of that?
It's Mr. Herlock's description of the conversation he had with Mr. Helzer when Mr. Helzer called him at Home Depot and asked to come interview with him. Mr. Herlock's testimony supports, it's a credibility determination, supports the trial court's finding that at that time, Mr. Herlock and Mr. Helzer agreed that the term was $50,000 for 6 months.
Thank you.
Defendant argues that if a contract was formed, the plaintiff is not entitled to recover the balance of the $50,000 because he did not work for the entire 6-month period of time. But he didn't work for the entire 6 months because defendant breached the contract. The balance of the $50,000 was the damages flowing from the breach. Plaintiff left his job at Home Depot for a guarantee of $50,000 for 6 months. That is what he would have been earned had AFO not breached the contract. And with respect to counsel's argument regarding mitigation of damages is an affirmative defense. The trial court made no determination of how much damage, what damages Herlock could have or did mitigate, and it wasn't Mr. Herlock's obligation to cross-appeal that issue. It was defendant's obligation to appeal the issue because the trial court didn't make a finding on that point. The trial court may have alluded to the mitigation of damages defense, but did not say, I find that Mr. Herlock could have made more money had he not done what he did after the employment relationship was terminated, and then he later went back to work, I believe it was for Walmart.
What about the defense that the defendant has asserted that there was a lack of consideration and lack of mutuality? What does the record show on that?
The consideration was Mr. Herlock would work for 6 months for $50,000, and AFO would receive his employment to perform the duties he was supposed to. But because defendant breached the contract, he did not and should not have been compelled to do that. But there was consideration. The consideration was, I, Herlock, will work for you for 6 months. You will pay me $50,000. The consideration goes to contract formation. The contract was formed. The breach is what caused the termination and the damages.
Counsel, I think the argument on consideration, though, is that if the contract is construed as allowing the employee to quit and still get paid $50,000, that is, not to work and still get paid $50,000, then there is no consideration.
Well, I don't think he could have, Mr. Herlock could have just quit and said, I don't like it here, give me the $50,000. The lack of, the failure of the consideration to come to fruition was caused by the defendant's breach of the contract by not paying him what the contract term provided for. With respect to the Wage Act claim, the Wage Act applies to wages that are vested and determinable as of the date of termination. At the time defendant breached the contract, plaintiff's wages were vested and determinable. As the trial court held, it was the definite amount of $50,000. And since plaintiff presented a viable Wage Act claim, the trial court properly awarded him attorney fees under CRS 84110. And we submit that the case of Lee versus Great Empire Broadcasting does not compel a different conclusion. In Lee, there was no factual determination whether the employment relationship was for a definite term. Here, I believe the trial court determined that the employment relationship was for the definite period of 6 months. And in Lee, this court held that the Wage Claim Act has been held to apply to payments becoming due after the date of discharge, provided that those future payments are vested and determinable at the time of the employee's termination. That holding is at 794 Pacific 2nd at page 1034. And here, plaintiff's payments were vested and determinable at the time the employment relationship was terminated. Also, in Part 3 of the Lee opinion, the court held that the amount earned by the plaintiff before his discharge was due and payable upon his termination and therefore subject to the Wage Act. Because it was necessary for the plaintiff there to institute suit to recover that amount, the defendant was liable for his attorney fees under the under the Act, and it was also necessary for Mr. Herlock in this case to institute suit to recover what he was owed under the parties' agreement. At a minimum, he was compelled to institute suit to recover the balance between the $9,000 he was paid, approximately $9,000 he was paid at the time of the termination, and the amount he should have been paid just with respect to that period of time. It should have been double that amount. So he was at a minimum compelled to bring a claim under the Wage Act for that amount. And plaintiff submits that he should be entitled to attorney fees for the first appeal and the remand proceedings. In Lester v. Career Building Academy, this court held that the 2007 Wage Act amendment declared that the General Assembly intended courts to interpret the discretionary standards for awards of attorney fees consistently with the United States Supreme Court's interpretation of attorney fee provisions in civil rights legislation. The attorney fee provisions in those statutes are intended to further the goal of ensuring that private parties enforce those laws. That is what Mr. Herlock did in this case. And plaintiff was the prevailing party in this case. This court did not award appellate fees for the first appeal, although they were requested under Rule 39.1 or then 39.5, because it was remanded for further findings on all issues, and procedurally the court couldn't reach the issue.
How could you say then that your client prevailed on the first appeal under those circumstances? It came away, I mean, I'm sure they weren't popping champagne when that came down. When it came down, they had lost the appeal and had to go back into trial court.
Well, I would argue that neither party won that appeal, but plaintiff won the whole case in the grand scheme of things, because on remand the trial court ruled in his favor again on all issues that were remanded. Neither party won the appeal. It was sent back for further findings on all claims.
So your point is that if you ultimately win, you're entitled to all your fees for all portions of all parts of all proceedings,
I think if,
regardless of whether you prevail on a particular issue or not.
I think if you interpret the Lester v. Career Building Academy case the way the General Assembly intended it to be interpreted, that should be the result in this, under these circumstances.
And there's cases under the Civil Rights Act that have held.
I can't quote you one, but again, plaintiff ultimately prevailed on everything. He was compelled to defend that appeal. He won again. He's the prevailing party.
Counsel, but hypothetically, let's say you had filed a motion for summary judgment and lost that motion. Would you be entitled to fees for that motion because you ultimately won the case? Or a motion to compel that was denied, or any other motion that was denied? You get all those fees anyway?
I think there might be a distinction between motions that the ultimate prevailing party himself made and procedural context in which the plaintiff is compelled to defend an appeal and then ultimately wins the same issues again. If defendant appealed the first time, not plaintiff, and in the context of what Your Honor is positing, it would be a motion for summary judgment that the plaintiff filed and failed to prevail on. That may be a distinction.
Counsel, you keep saying he won again, but you earlier said he did not win the first time. Nobody won the first time, so what do you mean he won again on appeal? So if he wins today, would be the first time he wins on appeal.
I'm sorry, I didn't mean to say he won on the first appeal. He won at trial.
Oh, okay.
He won in both trial proceedings.
But you want the fees for the first appeal that you agree he did not win.
Yes, because he ultimately won on the same issues that were raised on appeal in the trial court.
Thank you.
Well, he didn't win on exactly the same issues. He won on the claims. But the division reversed the court's finding, basically saying that the way the court went about it, that's just not a proper way to do it. So it wasn't like the trial court went back a second time, did the same thing, and that was okay, you won on that. The trial court went a different direction.
But he won the breach of contract and wage act claim in trial 1, and he won those same claims in trial 2. That is my point.
Okay, so let me give you another hypothetical. You say we should win on this claim for 3 reasons, and you ultimately win for 1 reason. You get your fees for winning for the whole thing, even though you didn't win for the other 2 reasons? And you might have spent a lot of time on those?
I think it would be, well, if you spent a lot of time on those and the time expended on other claims or issues are not so intertwined that the court can't segregate them out, then no. But if they are intertwined, courts typically will award fees, the entire amount of fees or a substantial portion of them, because the time expended on prosecuting one claim is so intertwined with prosecuting another claim that they can't be segregated out. And I see I'm running out of time. Unless the court has further questions, I have no more. Thank you.
In terms of the Wage Act claim, Lee could not be more controlling. Now, Mr. Herlock argues there was no finding in that case that there was employment for a definite term. That is a separate issue. The Lee court said that would be an argument under your breach of contract claim. That is not an issue under the Wage Claim Act claim. That claim cannot get you future compensation, whether you use the term guarantee or not. Lee is directly controlling on that issue. The Wage Claim Act must be dismissed in this case if this court is to follow its own precedent.
Counsel, let me ask you about that, though, because, I mean, you're saying that that's an all-or-nothing thing, but Mr. Herlock did work for a period of time. So doesn't he get his claim under the Wage Act for that period of time?
He was paid under the contract for that period of time. If this court were to agree with his interpretation of the contract to get him an extra $9,500, that again goes back to the determinability issue, because it still has to be determinable at the time of termination. And because the trial court denied summary judgment, said, I need a trial on this, we went up here, this court said that compensation term is ambiguous. It can reasonably be interpreted two ways. That cannot be said to be determinable at the time of termination, so the wage claim goes away entirely. In terms of mitigation, the trial court did in fact make a finding that he failed to mitigate his damages, but said it didn't matter because of the wage claim.
Actually, counsel, the only thing the court said was there's been credible evidence of it. That's not a finding.
And then said, that's it, that it doesn't matter for me to analyze it any further
Okay.
because of the Wage Claim Act claim.
So, exactly. So wasn't it incumbent on you as the party asserting the affirmative defense to request a ruling on that issue?
At that point, we appealed the Wage Claim Act claim, and Herlock never argued, no, in fact, there wasn't credible evidence of mitigation.
It wasn't his defense, it was yours. You had to request a ruling on that issue to preserve it.
I disagree. I think what the trial court said was enough, and we certainly argued that plenty to the trial court, failure to mitigate. I mean, that was preserved time and time again because it was a defense presented at trial. It was argued by AFO at trial, and evidence was presented on that. So it was preserved.
Thank you,
I
counsel.
see time is up.
I think your
Thank you.
time is up. Yeah. All right, thank you, counsel, for your arguments today. The case will be deemed submitted. We'll issue an opinion in due course. We'll go ahead and excuse you so that the folks for the second argument can set up. Any questions about our procedures? No, Your Honor. Okay, then we're ready to proceed.
Thank you, Your Honor. May it please the court. Michael Blanton, bar number 43031, on behalf of plaintiff and appellant Stella Hernandez. Unless the court has other issues it would like to hear about today, I would like to focus my time on the standard of proof issue. And while I don't want to delve deeply into the facts, I've covered those at length in my brief, I think it's important to note that the district court itself was troubled by the standard of proof issue during the Trinity hearing. It noted that on the opening day of the hearing, and again, on the last day of the hearing, the district court indicated it was confused by the standard of proof in the context of our facts. I think what it comes down to is the determination of the standard of proof depends on the type of issue that's being addressed. If you're addressing an issue of immunity or jurisdiction, issues that the jury will never consider, they would never be presented to the jury, then it makes sense to have the trial court act as the sole fact finder under a 12b1 type standard. But if you're addressing an issue of exemplary damages and willful and wanton conduct in that context, an issue on which the jury would at least sometimes be the final fact finder, I don't think it's correct for the trial court to apply a 12b1 type standard. I think in that circumstance, the trial court should apply a summary judgment type standard and should view the evidence from the perspective of the jury. It should ask, is there evidence that a jury could rely upon to find willful and wanton conduct?
Counsel, I have a couple questions
Yes, Your
about that. page 183 of the transcript of September the 28th in the discussion of this issue, where the court is trying to figure out this, what the standard is.
Yes, Your Honor.
You said, quote, "I agree, it's not a summary judgment standard," end quote.
And let me clarify, I agree that we were not in a summary judgment proceeding. At other places in the transcript, I think what the phrase I would use was summary judgment type standard. We weren't having we hadn't filed summary judgment motions. We weren't having a summary judgment argument, obviously. But I repeatedly argued to the district court that a summary judgment type standard should apply and that the evidence should be viewed from the perspective of the jury. So if I was unclear in my language in at one point, that's what I meant. Was that, I agree, we're not in a summary judgment proceeding, but repeatedly, and I've pointed this out in my brief, I took the position that a summary judgment type standard should apply. And for what it's worth, I think the standard of proof that applies under the law is what the law is. I don't think I can concede, I don't think a different standard of proof can apply because I say, let's apply a different standard of proof.
No,
So
I'm just pointing that out because
Right.
you say one thing in the trial court and say something different on appeal. We usually say you can't say the different thing on appeal.
And I understand that. And if I spoke inarticulately at that one point, but I think if you look at the whole record, which I've quoted repeated portions from, there are numerous instances where I make this argument to the district court that the evidence should be viewed from the perspective of the jury under a summary judgment type argument. So I apologize if I spoke inarticulately in that one instance.
Well, I do want to follow up because this is kind of a tricky kind of issue. Let's say there wasn't a waiver involved, as there is in this case. It was found by the trial court. And the employee can only be liable in that circumstance, the employee is immune from liability unless his conduct was willful and wanton. In that circumstance, doesn't the trial court have to determine as a factual matter in a Trinity hearing whether the employee's conduct was willful and wanton? Because it is an immunity issue.
Under that factual scenario, I agree, Your Honor, and that's why this gets confusing, because under the GIA, willful and wanton conduct can be important for two completely separate reasons. It can be the basis for finding an exception to immunity, but completely aside from the question of immunity, it can also be pertinent to the ability to seek exemplary damages. And so, and I agree, in the first instance, if the issue of willful and wanton conduct had been important because we were saying, well, the defendant isn't immune because their conduct was willful and wanton, that would be an issue of immunity. And it's my position that if you're dealing with an issue of immunity or jurisdiction, a Trinity hearing is appropriate, and that standard is appropriate. But when you're dealing with willful and wanton with respect to exemplary damages, that's not an issue of jurisdiction, and it's not an issue of immunity. And if you look at the Supreme Court cases on this, all of those cases make it clear that you have a Trinity proceeding when you're addressing a jurisdictional issue or an immunity issue. Trinity said that from the very beginning, that it was jurisdiction. In Finney, the court expanded that slightly and said it can be both a jurisdictional issue or an immunity issue, even if it's not jurisdictional. But all of the Supreme Court cases have said you have a Trinity hearing if there's a jurisdictional issue or an immunity issue. And when willful and wanton is only being considered with respect to exemplary damages, that's neither jurisdiction nor immunity. So it's not proper to apply the Trinity 12b1 type standard. While the Supreme Court hasn't addressed that exact question, I believe a panel of this court came very close in the case of DeForest v. City of Cherry Hills. In that case, the court directly addressed willful and wanton conduct in the context of exemplary damages. And that issue was addressed on summary judgment motions in that case. And the court, and I agree, I suspect defense counsel will say that the court was not faced with the question of should we apply a summary judgment standard, but the fact is that's how the issue was resolved in that case. And the appellate court seemed to have no problem with that. And I suspect if the appellate court had thought the wrong standard of proof had been applied, it would have weighed in and said this wasn't done correctly, as courts have frequently done in Trinity-type cases.
Mr. Blanton?
Yes, Your Honor.
Sorry to interrupt you. I'm getting the feeling from your arguments today that you think a Trinity hearing should not be held in this situation.
That's correct.
But did you object to the court holding a hearing?
I did not object. Instead, I argued what the standard of proof should be at the hearing. So I did not object to the holding of a hearing. I consistently took the position, I believe, and again, there was an instance where I may have misspoke, but I consistently took the position from the early argument all the way through that the evidence should be viewed under a summary judgment type standard.
So, sorry,
go
but
ahead.
under the standard that you think should apply,
Yes, Your Honor.
is there any point to have a hearing, evidentiary hearing?
I think there can be. Again, I think there's a couple of possibilities. I say it's a summary judgment type standard. That could mean a summary judgment motion. In their response brief, the defendant takes the position that all of this has nothing to do with the GIA, and that instead, the issue of whether plaintiffs can seek exemplary damages should be addressed under 1321-102. I think that's significant because under 1321-102, again, you view the evidence from the perspective of the jury. It's not a 12b1 type standard. So I think we may have disagreement about the mechanism that should be used, and that's why I've always said summary judgment type standard. I'm not saying there's only one type of proceeding at which this could be addressed, but I think it could be appropriate for the court to have an evidentiary hearing because, again, the idea is to address issues early in the case, but when the court considers that evidence, I think it has to consider it from the perspective of the jury. And the question should be not, do I as the judge personally think that this evidence establishes willful and wanton conduct, but because this is an issue that would eventually be decided by the jury, the judge should say, do I believe there's evidence that could support the jury finding that there's willful and wanton conduct? And I think that's important in this case because on the record, the district court at one point essentially indicated that if I were looking at this from a summary judgment type perspective, I'd almost be compelled to say, or it will be likely to say, that the evidence does support that finding. So I think the district court understood the crucial distinction of this standard of proof and the way it was looking at the evidence. I respectfully suggest that the district court got it wrong and that it applied the wrong standard, that it should have applied that summary judgment standard. I mean, even the district court noted the oddity of what it was doing. It said, it does strike me as odd that if I were to find willful and wanton conduct by a preponderance of the evidence, then you have to go prove it again to the jury. And it is odd. That makes no sense that we would have to prove by a preponderance of the evidence twice the exact same point, once to the judge and once to the jury.
But Mr. Blanton, wouldn't that be true in the case like the Martinez case, where there wasn't a waiver by the public entity, and so the public employee's immunity depended on whether the conduct was willful and wanton? So if the court holds a Trinity hearing, let's say the court does find by preponderance the evidence that the conduct was willful and wanton. If the plaintiff also wants to get exemplary damages at trial, don't you have to prove it again to the jury?
Well, in that instance, I think you have to parse. If you're in Martinez, as you indicated, the court was looking at willful and wanton with respect to immunity, and the jury would never address whether willful and wanton conduct was established for purposes of immunity.
But it's the same
Now,
standard,
if the
right?
court, but I don't think you'd ever reach that situation, because if the court finds that if the court finds that there's no immunity, I mean, you would have to, if you sought exemplary damages
Exactly,
in that case,
right.
you would a second time, but on a different issue. You wouldn't be having to establish the exact same point to a jury twice.
I mean,
But
the consequence of proving willful and wanton conduct would be different, but it's the same issue. The same conduct is at issue, and the same standard and definition of willful and conduct is at issue. So in that situation, if you wanted exemplary, you would have to prove it twice to two different fact finders.
I think at least I mean, if you had a hearing and the court addressed the issue of willful and wanton conduct and found that a record of willful and wanton conduct was established, and I hadn't thought about this, frankly, but I think you could argue when it comes up for exemplary damages to say the court has already addressed that issue. You know, I mean, the court's basically found it as a matter of law that that's how that evidence has to be viewed. But I still think you can separate it. I mean, the core of this is that you only have Trinity-type hearings for issues of immunity and jurisdiction.
Counsel, I want to stop you there because this confused me in reading the transcript. You yourself kept referring to it as a Trinity hearing. This is a Trinity hearing. And now you're saying it's not a Trinity hearing. And I can see then why the trial court is saying, look, both parties agree, preponderance is the test, no objection. I can see where the court could have gone the way it went.
The problem, and I agree that it's confusing, but I think the confusion was all around, because the way from the first day of the hearing, the way that the court presented it was, we're having a Trinity hearing, but tell me what the standard of proof is going to be with the issue we're dealing with here. So we all tended to view it as it's a Trinity hearing, but should the standard of proof be what it usually is? And I kept arguing, no, it should be a summary judgment type hearing. So or a summary judgment type standard. So, I mean, we can call the hearing. I agree. I would refer to the hearing as a Trinity hearing, because that's what it had been docketed as, that's what defendant had requested, and that's what the court said we were going to have. But I never agreed that the Trinity standard, that the 12B1 type standard should be what applied. I don't believe there's a single instance in the record where I said, yes, the court should be addressing this under a 12B1 standard. I think I always said the evidence should be addressed from the perspective of the jury under a summary judgment type standard.
Can I just
yeah,
quick
sure.
ask a question? You keep talking about exemplary damage, but isn't the willful and wanton also relevant to the damage caps?
And that's what I'm saying. In our case, that was the only issue the willful and wanton was relevant to, was the damage caps. And because it wasn't being addressed with respect to immunity, instead it was being addressed with respect to the caps, that's not a jurisdictional issue, and it's not an immunity issue. So the court shouldn't have applied a 12B1 standard.
And that's not an issue that the jury would deal with, though, is it?
Oh, it is. When we, in order to
caps?
add exemplary damages to our petition.
No, for the damage caps.
The jury wouldn't decide
Right.
a damage cap, but the jury would have to decide
understand.
whether there was willful and wanton
And wouldn't they
conduct.
have to prove that beyond a reasonable doubt in a
I don't believe it's beyond a reasonable
Yeah,
doubt, Your Honor, but
okay.
yeah, I think it's
It's
clear.
been
and
a while
correct,
since I
Your
looked
Honor.
at that.
Yes. If it's okay with the court, I would like to reserve a little time for rebuttal. Thank
Sure.
you.
Thank you, counsel.
May it please the court, my name is Michelle Horn, bar roll number 32599, and I represent Tracy Dotson. This matter got before the district court on a motion by defense for a Trinity hearing to decide the sovereign immunity of defendant Tracy Dotson. Tracy Dotson, as a deputy sheriff employed by the city and county of Denver, is entitled to assert sovereign immunity to any claims made against her stemming from her employment. And sovereign immunity is a bar to suit, which is why the Trinity decision came about, and the courts hold Trinity hearings to determine whether or not the individual can be sued. The allegations in the complaint concern what happened to plaintiff Stella Hernandez when she was a pretrial detainee in the custody of the Denver Sheriff Department. The CGIA, the Colorado Government Immunity Act, provides a waiver of sovereign immunity for such a situation, although only for negligence and only up to a $350,000 damage limit. However, the complaint contains allegations of willful and wanton conduct against Deputy Dotson, which implicate her sovereign immunity. If she isn't found to have engaged in willful and wanton conduct, she is exposed to the possibility of personal liability for any related damages, including exemplary damages if they are ever awarded, and she is no longer entitled to free legal representation by the government entity, in this case, the city and county of Denver. All assertions of sovereign immunity, whether jurisdictional or otherwise, must be decided pre-trial, and that is because, as I mentioned before, sovereign immunity is a bar to suit. This includes, according to the Martinez case, allegations of willful and wanton conduct. Trinity Broadcasting and its progeny set forth standards by which the trial court determines such issues. First of all, the burden is on the plaintiff to prove willful and wanton conduct by preponderance of the evidence. That's from the Finney case. It's determined in accordance with a 12B1 standard. The trial court is supposed to, as the trial court did here, weigh the evidence, determine credibility of the witnesses, and make factual findings based on the record.
Can I ask a question?
Yes.
Was there any dispute that the immunity had been waived by virtue of it being pretrial detention in a jail?
For negligence only, there was no dispute. Your
No
Honor.
dispute. So the only issue that willful and wanton was relevant to was not whether or not immunity had been waived, but whether there were entitled to, whether the plaintiff could seek exemplary damages and damages beyond the $350,000.
No, Your Honor, the trial court had to determine whether Ms. Dodson herself should be held personally responsible for the damages in the case. She is immune from damages, immune from suit, unless she is found to have engaged in willful and wanton conduct.
Counsel, but the statute, 2410-118-2A, that you're relying on, that says, that grants that immunity, unless that act or the act or omission causing such injury was willful and wanton, is followed immediately by a clause that says, and I quote, "except that no such immunity may be asserted in an action for injuries resulting from the circumstances specified in section 2410-1061. That is the waiver provision.
Your Honor, the waiver provision applicable in this case is 2410-1061 1.5b, which says if it's a pretrial detainee, the waiver is for negligence only.
Actually, it's in 1B, which says that the public entity waives immunity for acts, for injuries resulting from acts committed by the operation of a jail in the operation of a jail. 1.5 simply says that that particular waiver applies only to pretrial detainees, not to those who have been convicted.
You're right, Your Honor, Ms. Hernandez was a pretrial detainee.
But the circumstances described in 1B are what gave rise to the waiver here.
Your Honor, I would argue no, that it is 1.5b, because it concerns a pretrial detainee.
That's just a limit on who. It's not a description of the circumstances as 1B is.
I'm not going to argue that further, Your Honor.
Okay.
Did you argue it in your briefs? I didn't see that argument in your briefs.
I mentioned that the waiver applicable was for negligence only and put the 1.5b.
Did you say that this was not a waiver under 1061?
And I'm not arguing that now, Your Honor.
So you're not arguing it in the briefs or now?
I correct, Your Honor.
Okay.
And I'm sorry for that confusion. Willful, if you give me a moment, Your Honor, okay. The specific remedy plaintiff is asking for in this case is that for this court to carve out an exception to the to the Trinity standard when the plaintiff is seeking exemplary damages. There are a couple of problems with that request. First of all, that particular request in that particular way was never presented to the trial court. In fact, the plaintiff disavowed any intent to seek exemplary damages in the trial court.
Actually, counsel, I don't think that's accurate. Counsel said that it hadn't yet done so because the statute barred it. There's a statute that says you can't assert a claim, it's not a claim, but you can't assert exemplary damages until you get leave of court after an exchange of disclosures, et cetera. So he was saying, I haven't done it yet, and the court recognized expressly that the plaintiff might well do so if it survived this hearing.
Correct, Your Honor. That is what the court said in the post-Trinity filing, but if the plaintiff was not yet in the position to seek exemplary damages, then he cannot have the position that the summary judgment standard should have applied if he was seeking exemplary damages. He simply wasn't in that position yet. Either he wasn't seeking it, or he hadn't sought it yet, so the exception that he's trying to get would not have applied in the position that the case was during the Trinity hearing.
But nonetheless, he was seeking to set aside the damage limitations, right?
He said he was seeking to break through the $350,000 damages cap, which would have held Tracy Dodson personally liable for any damages resulting from the incident with Ms. Hernandez.
And it would have also held the city and county liable for damages beyond the $350,000.
No, Your Honor, damages, the city and county of Denver is not liable, does not pay exemplary damages according to the CGIA.
I'm not talking about exemplary
But
damages.
if there were any damages awarded beyond the $350,000, I don't necessarily agree with you there, Your Honor, that that would break the damage cap according to the city and county of Denver, although it certainly would have with Ms. Dotson.
Counsel, the cap, though, is not an immunity issue in terms of immunity from suit,
Correct, Your Honor, it's
It's
immunity from damages.
from damages. Okay.
Yes, Your Honor.
Well, isn't that also true of whether or not Dotson is personally liable? I mean, whether or not she's personally liable, she's not immune from suit. There wouldn't be any damages from which she could be personally liable or not if you didn't go to trial. You can only assess that question about who's liable for damages if the person is not immune from suit and you go to trial and there are damages.
As I mentioned before, there are several aspects of her sovereign immunity related to willful and wanton conduct, and only one of them is related to the damages issue. Another one is related to her, whether or not she can be personally liable for anything.
Right, but that's not immunity from suit, right? She could still, even if she's not personally liable, she's still going to trial,
Well, if
and
you-
she's still going to be a defendant at the trial, and there might be damages awarded.
You know, I do not agree with that. I think
You don't think she's going to be a defendant at the trial and have damages awarded against her if the jury finds that she was negligent?
No, Your Honor, the damages would be solely against Denver in that
So
case.
she's not going to be a defendant anymore?
She will not be a defendant anymore. The defendant now, well, let me explain that. Let me back up. There is her official capacity and her personal capacity. What we're talking about here is Deputy Dodson's personal capacity to be sued under the CGIA. If we go back and we have a trial on this, she will still be a defendant in her official capacity, which is the same as suing the city and county of Denver.
Thank you.
Your Honor, and while counsel did discuss the summary judgment standard in the trial court below, the plaintiff's counsel never specifically linked it to seeking exemplary damages. So the trial court was never able to determine whether what the plaintiff is asking you to do now, in that specific instance, when you're seeking exemplary damages, whether the summary judgment standard should or should not apply. Your Honor, a review of the record shows that the trial court's factual findings were based on the record and not clearly erroneous. I do not believe there is any basis in case law, statute, or the record for plaintiff's position that there should be an exception carved out in this instance for a summary judgment standard when he is seeking exemplary damages. And I'm asking you to affirm the trial court's decision.
Why did if there wasn't yet a claim for exemplary damages, why did the city seek to have a Trinity hearing at that stage?
We sought a Trinity hearing to limit the personal liability, the personal exposure of Tracy Dodson to willful and the consequences of willful and wanton allegations.
And you're saying that's the kind of immunity that is contemplated by cases like Martinez versus Black?
Yes, Your Honor, her sovereign immunity, yes.
Counsel, that seems to be immunity from a certain amount of damages, which is a liability immunity, not an immunity from suit. My understanding of Trinity in 12b1 is that's limited to hearings to determine immunity from suit.
Correct, Your Honor, and as I explained when Judge Navarro asked me the similar question, is that she would be, for now on, immune from suit in her personal capacity, but not in her official capacity.
So would she remain a defendant in her official capacity?
In her official capacity, yes, Your Honor, which is the same as suing the city and county of Denver.
So that's very different than in Martinez, because in Martinez, if the conduct was not found to be willful and wanton, the case would end right there. There would be no trial against any defendant.
Yes, Your Honor, that is correct.
But yet you rely on Martinez a great deal. That's
I
what,
do rely
that's what
on
confuses me.
Martinez a great deal because it is the only Supreme Court case to discuss the issue of willful and wanton conduct with a government employee.
Right, but in that case, there was no waiver of the public entity's immunity under 106.
That is correct. That is a distinction with Martinez in this case.
Okay.
Thank you, Your Honors.
Thank you.
Your Honors, I think opposing counsel summed it up at the beginning of her argument when she said a Trinity hearing is to determine if a defendant can be sued. There's no question that Ms. Dotson can be sued. The district court said that at the hearing, and if there were any question in the post-hearing motions, the court made clear Ms. Dotson is still a defendant. And by the way, I disagree with the assertion that she's only a defendant in her personal capacity. I don't think that's consistent with the court's orders. I think the court has said that it addressed willful and wanton with respect to exemplary damages, but Ms. Dotson is a defendant in the suit for all purposes. I don't think the court has drawn the line and said she's now only a defendant in some respects, but not in other respects. I'm not familiar with any order in this case that says that.
But counsel, I think the argument seems to be that the court needs to determine this willful and wanton question at this point, because if the conduct was not willful and wanton, then the individual can only be a defendant in the individual's representative or official capacity.
I'm not sure that that's an entirely accurate characterization. I think it says that the individual defendant will be individually liable for exemplary damages and won't be treated in an official capacity for that purpose. But I don't think it says they can't be a defendant. I mean, I think in terms of the negligence claim, she's still a defendant for all purposes. I don't think the district court has said that she's now only a defendant for some purposes and not for others. I think the ruling was only as to exemplary damages. I think the bottom line here is the district court should have never applied a 12B1 standard. Exemplary damages is an issue that generally goes to a jury, and properly so, and the district court should not act as a jury of one on that issue. If it was an immunity issue, that'd be one thing, but when it's an issue that would go to the jury, the court should not act as a jury of one. I'm sorry, Aaron, please.
That's okay. We're over our time, but I have a question. You keep talking about exemplary damages, but as I think we've been fleshing out here, there was no issue as to exemplary damages at the time of this hearing. You hadn't requested permission to assert them, and the hearing was over the cap. So why are we all talking about exemplary damages now?
Well, because I think they're intertwined. I mean, that's absolutely correct. We hadn't filed a motion yet to add exemplary damages to our petition. And I think it's even confusing. Defendant's position in their brief seems to be that issue's not even ripe yet, that presumably when we get back down, we could now file a motion to add exemplary damages. I think it's hard to separate those two issues of the cap, because if there's a cap that says you can't seek exemplary damages, that seems to overlap the statutory basis for allowing you to seek exemplary damages, and they both apply a willful and wanton standard. But I do agree, we had not yet filed a motion. That is certainly something we had intended to do, but this was a hearing that came up early in the case on motions to dismiss.
Thank you, counsel.
Thank you.
Thank you, counsel, for your arguments this morning. Take the case under advisement and issue an opinion in due course. That was the last case on our docket this morning, so we'll be in recess. The bailiff may so announce.